welcome to the Womxn Show. I'm Lenina Rasool. Last week saw the end of Women's Month 2021 under the theme Generation Equality, Realizing Women's Rights for an Equal Future. And so it was fitting that Women's Month ended on a high note with a High Court judgment that was deemed a victory for women and survivors of gender-based violence across South Africa. The case in question was that of Reverend June Dolley-Major, who several months ago publicly named the man accused of raping her in 2002. The accused, Melvin Booysen, then instituted legal proceedings against Reverend June to stop her from mentioning his name on social media and other platforms. On the 30th of August 2021, the judgment came in favor of Reverend June Dolley. And it is a phenomenal judgment for women everywhere who have sought to publicly name their rapists without a conviction. After the break, we're going to be speaking to Reverend June and the Women's Legal Center, who were admitted as friends of the court in this case, to ask what does this judgment mean for us. But before that, we're going to have a look at a short video by Reverend June, who has been live streaming about her case for a while now, for context about what led up to this judgment. Let's have a look.
A lot of people have messaged me and asked me how am I feeling, seeing that the Women's Legal Center has come on board on my GAG order. How am I feeling, seeing that the tribunal is actually happening? And yeah, still lots of emotions, mixed emotions, wonderful emotions, good emotions. I actually today want to speak specifically about the GAG order actually. And just looking back and reflecting from where I've been, what I've been through and where I'm at right now, it's been a long journey. Honestly, it's been a long journey, and I want to just reflect back a bit. My journey took me through various phases in my life, a lot of phases, and I'm speaking now from the night that I was raped. Good afternoon, Robert. Hope you're well and keeping warm. So it takes me back. I want to reflect back over these years and obviously not go into all detail. But as you know, I was silent for many years because of what my bishop had told me and how he threatened me. And if you look at the tribunal, you can in fact see how bishops speak to their supposed subordinates. And so that is how I was silenced for many years. Many people say break the silence, and I'm just reflecting back over the past probably year as well. They say break the silence, and it was not easy always to break the silence because of vilification, body shaming, victim blaming, people believing the other version, the version of the rapist. So it's not always easy for you to tell someone break the silence. I came to the point, and as I said, I'm just reflecting over the different phases I had to go through. I came to the point where I had to break the fear before I could actually break the silence. And break the fear in different aspects. The fear of, what if I speak out and they don't believe me? What if I speak out and my witnesses whom I told lie? What if I speak out and I get fired? What if I speak out and, as the bishop said, you know, use the canon laws against me? So I had to break that fear. Hi Chaz, hope you're well there. Haven't seen you in a while. And a lot of other people, for example, if you're raped by a gangster, the fear of breaking the silence is your gang members going to go after me? Will they kill me? Will they kill those whom I told? And so all these things, so you have to physically actually break the fear before you can break the silence. So I had to physically break the fear of everything that was happening around me, to break the silence. And in breaking that fear and breaking that silence, it has been a hard journey. It's been a tough journey. The vilification came, you know, my bishop said, oh, she's crazy, she's lying. And all these things that got added to it. Papers were withheld, so I couldn't work. Up until today, I'm still not working. Ended up on the streets, ended up in a shelter. So it took a huge sacrifice. However, right at the start, and people say, what caused me to break the fear? And a family member was raped, as I said before, and by a family member, by her family member. And I told the dad, you need to break the silence and you need to report the matter. And the dad said, well, he's protecting his family member. And I said, but you can't. It's your child at the end of the day. And when I said those words and I uttered those words to him, I realized that I was being a hypocrite. Because just as he was protecting his family member and didn't want to bring shame to his family because it was a family member that raped his daughter, I, in fact, was doing the same, not protecting a family per se, but protecting this institution that I've been told I need to protect. That if I break the fear and break the silence, if I break the silence, that I will bring shame to this institution. So it was in that moment when I realized I'm being a hypocrite and I need to break the fear. If I tell other people to break the silence, I needed to break the fear in order to break the silence, which I did. In my wildest dreams, I never thought that the attacks would come as they did. I never thought that I would have to sell furniture, my car, every worldly possession just to survive so that I could pay for rent, so I could buy food, so I could buy toiletries. Never in my wildest dream did I ever think that it would come to that, because the institution that I approached was a religious institution and I thought that would be a safe space. So I never thought that the backlash would be so heavy, the sacrifice. However, I realized if it was so hard for me, I could just then imagine it's just as bad for others out there, victims and survivors who wanted to break the silence and break the fear. And I had a bigger picture in mind. I knew ultimately, and that's why I've gone public as well, I knew ultimately it's not just about me, myself, and I, but it's about every victim and every survivor out there. And that's why I actually broke it. And I went through different phases, as I said. It was the break the fear, break the silence phase. And then I went from pain to power. And you know, I've posted a lot about that, moving from pain to power. So many victims and survivors stay in that victim mentality, stay in that victim state and feel powerless. So many of us attempt suicide, myself included. I also at one stage attempted suicide and I had to ask God to forgive me.
We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching the Womxn Show, and tonight we are speaking about the silencing of victims of rape and gender-based violence and a recent High Court order that actually was found in favor of a victim who has named her rapist. And with us now is Reverend June Dolley-Major, who was at the center of this case for defamation. And the judge found in her favor, as we heard before the break. So, Reverend June Dolley, I'm not going to go further. I'm actually going to speak to you to just ask us, to tell us, what that case was about and what this victory means for yourself and for other survivors of violence.
Hi, thanks, Lenina, and thank you for having me. I'm still happy, I'm still elated, I'm still over the moon at the ruling yesterday by Judge Bartman, because as you know, the trend today is that they rape us and then they use their constitutional rights to go to court to then take gag orders out against us to silence us, and then expecting us to pay for that silencing. And sadly, in South Africa, we have a less than 10% conviction rate when it comes to rape. So it does not mean that if the court says that the person is not guilty, that he is not guilty. And so by my rapist going to court and taking out a gag order against me, sent a very clear message that, you know, he can rape me and then silence me for the rest of my life, that I cannot say his name and talk about what he did to me or mention him, and also warn others about him. So by the judge making this ruling yesterday, it was a victory for all survivors. It was a victory for all South Africans, because we know that South Africa is the rape capital of the world. We know that every day, every few minutes, someone is getting raped or abused, and 1 in 3 women in her lifetime will be sexually molested or raped. We know that is the reality. And so with this ruling of Judge Bartman, it says that even though court did not find him guilty, he is still my rapist, and I can say his name. So that was just mind-blowing for me. I was just, yeah, it was just really amazing for this outcome, not just for myself, but for every other survivor out there, because we now send a message to survivors that there is hope. We can say their names. We send a message to perpetrators that they can no longer run to the courts for protection, in silencing us so that they can continue to doing what they're doing and re-offend, because for various reasons, you get a nollie prosecution or not guilty. Either the victim is too traumatized to testify, too young to testify, or the witnesses lie and cases get thrown out. But when you raped, it's you and that person, you and your rapist. So there's no other witnesses most of the time. So it's your word against his word. So this ruling yesterday honestly set precedent for all survivors, and it was a good day for us in South Africa, in all honesty.
Yeah, thank you, Reverend June. And what was interesting is, you've come out, this is a long time. This is, I think, almost 20 years after the rape occurred. And, you are someone that you did not disclose immediately. So what was interesting for me in this case was that you were told to think of the church and to think of the church's reputation, yes, both in the immediate aftermath and also sort of throughout the years. And can you tell us, you also work with survivors. So are these some of the things that are used to silence women, to prevent them from speaking out sort of initially?
Yes, definitely. And I think with me going very public with my case, it shows the life of a survivor. So in my case, I was told to be silent to protect an institution, the Anglican Church of Southern Africa. But many times the rapist is known to us. It could be a family member, a father, a grandfather, an uncle or brother. And we are told to be silent to protect the family. We are told to be silent to protect politicians, church leaders, religious leaders. And so this is the norm of silencing. And we ask ourselves, why do we keep quiet? Why are we silent? Why do we not prefer to suffer in silence, but why do we? Why do 1 in 9 only report? And if you look at my very public coming out and breaking that silence, you see the vilification, you see the attack, you see the victim blaming, the body shaming, you see even with the tribunal, even though it wasn't a criminal case, but that is how you get ripped apart as a victim. And so, yes, you remain silent because of different fears. And so society silences us, community silences us. But out of the pain and the fear of what could happen if you break the silence, you actually also keep silent and you suffer in that silence. So yes, that is the norm where you are literally pushed into silence.
Reverend June, so I'm always, fascinated with that statistic that you mentioned, that our conviction rate is around 10% in South Africa. And I always cite it because I don't think many people know. And what's interesting for me is that means the majority of perpetrators actually do get away with it. They go back out, they don't go to jail, and as was your case. And so I want to ask you, because I read, even so many years later, you were found to be suffering from depression and PTSD as a result of that rape. I'm talking about the cost of keeping silent, because one of the things they often say is, oh, well, why didn't you say anything? It was so long ago, like as if it didn't affect you. Can you speak just a little bit about that?
Yes, it does affect you. And it doesn't matter if it happened a year ago, a day ago, 20 years ago, 50 years ago. It has long-term effects on you. It changes your life. And it's easy for people to say, why didn't she speak out? You're not in the shoes of a rape survivor. Look what happened when I did speak out, in fact. And the fact that I'm maybe become a known activist, so I've got the support and the people standing by me. But what about the person that's not known? And when they attacked and when the communities come after them, I mean, if you look, some of my colleagues said some very vicious and vile stuff about me, clergy who said those things. We had a known clergy person who doomed me to hell and said I was diabolical and satanic. So that is the reality that we face. And yes, it's not easy to break that silence. It's not easy to speak out, but we have to reach that point where we're saying, listen, enough is enough now.
And so, Reverend June, and I wanted to ask about that even in the aftermath, and it's been really hard, and there's been so much going on, and you have garnered lots of support, as you said, but on the other side, also, been vilified by people by colleagues, by communities, and that still must hurt. That still must sort of, hit hard. And so, for survivors who are thinking about, and I say this with no pressure whatsoever, because that is everybody's personal decision in terms of how they want to move forward. But if there are those who are thinking about speaking out, what can you say or what advice can you give them to assist, I think, them in preparing for what that aftermath might look like?
And I'll be very blatantly honest, and I think it's important that we shouldn't sugarcoat it. With me breaking the silence, and I always said it, I had to break the fear first before I could break the silence. And that's the story of every survivor, having to be able to break the fear to break the silence. It's hard. The triggers are tough. It's real. As long as it's been, even for me, I am triggered still. I still get hurt. I still have my nightmares. I still cry. And people see the activist, the strong person, but there's also a side that is in fact triggered by all these things. So I'll be blatantly honest, for if you want to break the fear and break the silence, it's not always an easy journey. It's tough, it's hard, but you also need to know that you're not alone. And to reach that point, because for so long he had power over me, I allowed that to still continue. But to be able to come to the point where I'm taking my power back and move from pain to power. And that is what we need to do. That too often we remain in that victim state where he still has that power, where he still controls our emotions. We need to be real. You know, the triggers are real. A lot of survivors turn to alcohol, to drugs. Some inflict harm and start cutting themselves. Some attempt suicide. And sadly, some have succeeded in suicide attempts. And that is real. And so for a survivor to come and break the silence, you need to know that you are not alone. And that when you reach that dark spot and there are going to be triggers, you're going to feel hurt, you're going to be reactive, have a support system around you. And for survivors to know that there are people out there that's there for them, that supports them, that cares about them, and that they are not alone. And also for the community to rally around survivors to show that, listen, you are not alone, that when you do break it, we are with you in this.
Yes, thank you so much, Reverend June. We've run out of time, but I want to say thank you so much, first for breaking the silence, and for, you know, congratulations for the victory, because it's a victory for all of us, and just for joining us here this evening.
Thank you so much, and thanks for having me. I truly appreciate it.
Now we are speaking to Attorney Chriscy Blouws from the Women's Legal Centre to unpack this issue of gag orders silencing victims, and also the recent judgment in the Western High Court that found in favour of Reverend June Dolley. Chrissy, thanks so much for joining us.
Thank you very much, Lenina.
So Chrissy, so we've had this positive judgment, this outcome that was in favour of Reverend June, and also that said, you know, essentially it was a defamation case, and I think the judgment said that they didn't find any reason for that, and partly that was because she had mentioned his name, or he was mentioned quite a while ago. But I was wondering, can you just give us sort of the unique aspects of this case?
Sure, Lenina. So Reverend June Dolley-Major and Melvin Booysen were both priests of the Anglican Church. And several years ago, around 2002, while Reverend June Dolley-Major was still in training to become a reverend or priest at the church, she was accompanied by Melvin Booysen along with other officials to, I think, Grahamstown, where the training was supposed to take place. And at that time, she alleges that she was raped by Melvin Booysen, and this is around 2002. Essentially, what happens is that Reverend June Dolley-Major advises that she sought assistance through the criminal justice system at the police. She had reported this to several officials within the church, and to no avail. She was not assisted, she was not believed. Things went wrong within the criminal justice system at the police or within the investigation, and essentially there was a decision not to convict or prosecute the charges against Melvin Booysen. As a result of feeling unheard, unbelieved, and isolated, further victimized by all of these processes, Reverend June Dolley-Major then decided to post on social media and publicly that Melvin Booysen had raped her, and she started posting in 2016. And since 2016, she has had an online campaign which sought to speak out about her own abuse, and also sought to create a platform and a sense of community for other women to speak out, to learn from her experience, to show that women can speak out, can be courageous when they stand together, but also as an opportunity for other victims to come forward who might have experienced the same things at the hands of the same perpetrators. And essentially what Melvin Booysen did was come to court earlier this year in 2021 on an urgent basis, seeking an interdict from the court to stop Reverend June Dolley-Major, Major Dolly, from posting online, and the interdict sought to prohibit her from indirectly or directly posting online, including his name, the name Melvin Booysen, in any of her posts, blocking his name from any of her posts, and or blocking third parties from posting about him. And he had initially obtained an interim interdict order in the Western Cape High Court earlier this year, which had ordered her to refrain from posting until the internal tribunal process as set up by the Anglican Church was completed. And the grounds on which he brought this urgent interdict was the fact that her posts were defamatory in nature and that they were causing harm to his reputation, to his good name, and to his standing within the community, especially as a priest. And essentially the matter was postponed and was heard in August, and we received the judgment on the 30th of August in relation to her matter.
Thank you so much, Chrissy. I mean, that's interesting. So I just want to ask, though, I mean, in this case, you know, the result is a defamation case. So that's what most victims are sort of threatened with. That's what happens. We've seen it happen here in South Africa already with previous, I'm going to say name and shame campaigns, but we know it's sort of naming perpetrators. So is there a case for defamation if someone names their perpetrator?
So, Lenina, I think what we must clarify, and why I specifically mentioned that Melvin Booysen's case was an interdict application. I think that oftentimes women are threatened with legal action within the court process, it not being always defamation. And what we found with several women who've approached the Women's Legal Center seeking legal representation and assistance in this regard is that we're finding more often than not women who publicly name their alleged perpetrators. Those perpetrators are coming to court using the Domestic Violence Act, using the Protection from Harassment Act, using urgent applications such as this interdict application to silence and effectively gag women from speaking publicly, when essentially it is within the defamation realm. So just in terms of the legalities in our current legal framework, defamation is the wrongful, intentional publication of a defamatory statement which concerns and has the effect of injuring the person's status, good name, or reputation. And the constitutive elements of defamation are wrongfulness, intentional, and the publication of that defamatory statement which concerns the applicant or the plaintiff, right? And that is a defamation application which should be brought against someone. So Melvin Booysen didn't bring a defamation application. He brought an interdict, which kind of circumvents the processes that need to be followed with regards to defamation and is a quick and effective way to stop someone from speaking, right? Because an interdict immediately restrains someone's constitutional rights that they may have without necessarily giving that person a fair opportunity to defend themselves. Because what he did is he got an interim interdict, which effectively stopped, gagged, and silenced her pending the final outcome of an interdict, right? So her rights were already restricted even before she had a fair chance to represent herself in court and provide her side of the story. And also, the problem with perpetrators going throughout these other routes is that defamation, although it is a claim which perpetrators have to their ability when they are being publicly named, defamation has valid defenses. And so there are several defenses to justify the publication of such defamatory publication, right? And these justifications, they speak to the elements of wrongfulness, and if proved, will result in a court finding that there has been no wrongful publication, which is exactly what happened in this case. So the traditional grounds and defenses that one can use with regards to defamation. So any woman who does publicly post about her alleged perpetrator and then is approached with a defamation claim has valid defenses such as being able to say that the statement is true and within the public interest. And those are two of the most important defenses which we see play out within these cases and which played out in Reverend June Major Dolley's case. So the truthfulness about this is an objective test. And that test is where the speaker, so the person who posts publicly, must prove that the statement is substantially true and not literally true. And that's also an important recognition, because we know, and the context that WLC brings to these types of cases is that rape does not always look as people think it should. And the context of the circumstances and the vulnerabilities and the evidence that plays out in rape does not always allow me to necessarily my truth to be literal, right? So the substantive truth is a defense to defamation, and also public interest. In determining whether a statement is within the public interest, considerations, for example, include the time, the manner, and the occasion of the publication, which is also exactly what played out in this current case, where the judge looked at, for example, the fact that Reverend June Dolley-Major had posted about this in 2016 already. Yet Melvin Booysen only came to court in 2021, 5 years later, claiming on an urgent basis that his rights are being violated. There is a 4-year gap in his claim to defend his rights, right? And also, she had sought other recourse, which is not necessarily an element in terms of defamation, but those are all factors which contributed to her being successful within this case. And then there are 2 other grounds of defenses to defamation, which is that the statement amounts to fair comment or freedom of expression, which is a constitutional right guaranteed to all women. And the third defense is that the statement is made under privileged circumstances. So while, yes, within our current legal framework, women who post on social media platforms can be sued for defamation, defamation has valid defenses.
Thank you so much, Chrissy. We have to take a short break, but we're going to come back to this after the break. Welcome back. You're still watching The Womxn Show, and tonight we are speaking about a recent Western Cape High Court judgment that sought to silence a rape victim and was actually found in her favor. And essentially the show speaks to people using the court process in order to prevent women from naming who their perpetrators are in cases of gender-based violence. And joining us now is Chriscy Blouws, who is an attorney at the Women's Legal Center, who was admitted as a friend of the court in this particular case. Chrissy, so before the break, you were speaking about, very interesting topics in terms of what is defamation, which is broadly what women are just threatened with, or victims are just threatened with. So we're gonna sue you for defamation, is what they say. And what you're telling us is that there are other things that can be done within the court process. In this case, with Melvin Booysen, it was seeking an urgent interdict to stop Reverend June Dolley from posting and from naming him in her social media posts. And then you were saying, which I also found really interesting, sort of using the Domestic Violence Act. And even I think, things that I've heard of have been protection orders also. So there'll be co-protection orders to prevent someone from speaking out about something, especially during a court case. And we've seen this actually in a few highly publicized cases with sort of high-profile celebrities, local celebrities. So I think I want to come back to just anyone is thinking about speaking out at this point. So you're telling us what the options are that are available to us. When I was researching this topic, the one side is speaking out about it, then there's legalities, and then there is lots of lawyers and attorneys also saying, also discouraging people from naming before a legal process has been sort of finalized. And so, and I think I'm asking a bit in layman's terms. If I wanted to go onto social media now and I wanted to say that this happened to me, it was this person, what would your response be to that?
So this is exactly why the Women's Legal Center joined this specific case. As I've mentioned before, we have several women who had approached the Women's Legal Center in the past 2 years, having been brought to court by the alleged perpetrator after naming them publicly, or after a third party had named their story and posted it, even without their consent at times. And what we see, as you have said, happening is that, yes, defamation is within our current legal framework and there are valid defenses to defamation. However, perpetrators are circumventing defamation and are using alternative legal mechanisms to kind of silence and victimize and gag women from speaking out. So we've seen men use the Domestic Violence Act, the Protection from Harassment Act, interdict applications such as this one. And the defenses, as I've mentioned, is truth and in public interest. However, it's difficult to bring up those defenses within an interdict application because an interdict has specific requirements that need to be met. And so that's how men are circumventing the rightful processes that should take place within defamation matters. And I've read what the other experts have said, for example, around these defenses to these statements that are being posted. But for myself, for a woman who wants to post on social media platforms, that something has happened to her, that is her truth. And while a feminist approach to allegations of rape presumes the survivor's truth, this is not a universal approach. And perpetrators often argue that an allegation of rape is only true if it is proved in a criminal court. And that is a big aspect of the case that we and the context that we brought before this court, because when someone is convicted and found guilty within a criminal process does not actually determine that they are guilty or innocent. We know that there are flaws within our criminal justice system. We know that there are flaws within the way that evidence is detained. We know that there are flaws in the way that witnesses come forward and just the nature of evidence, particularly within rape matters. And so therefore, we do not believe that a conviction is the sole indication of whether someone is truthful in whether they allege rape or not. And so the defenses of defamation is important for women to consider when they decide to post. Because if I am posting and it is true, I can prove, for example, some of those defenses are, if I have witnesses that saw the rape, or if I have gone to the police station to lay a criminal charge, and for example, if I have other factors that are able to help kind of prove my truth, then that is my truth and that is a defense to the defamatory statement. If it is within the public interest, for example, the person who had allegedly raped me has access to various other women. They might be minors, they might be women where there's a large power imbalance. And so I am doing this within the public interest to warn other women, to protect other women, which most of the women, including Reverend June Major Dolley, had said was the purpose of them posting, then that is also a defense to that defamatory statement.
Thank you, Chrissy. I mean, that is, again, so very interesting. And it's looking at, I mean, I totally get what you're saying. And, you know, I did want to bring in this issue that is often, for years and years and years, been used to sort of circumvent this conversation, is the allegation of false accusations. So this is the one that's thrown at everyone. You cannot publicly name someone because what if it's a false accusation? And we're not saying that false accusations do not happen. They are, I think, even just globally and historically, especially when you look at it from, you know, from a race perspective, that false accusations have been used within that context to prosecute men, to prosecute innocent men. But you know, there's one statistic or meme, I should say, that goes around on Facebook regularly, which is the 2%. I think it's a US statistic that it's been found that only 2% of allegations or accusations of rape are false allegations. But you know, is there a local context for this? Do you have as a feminist legal organization, what is your response to the false accusation argument?
So within the case of Melvin Booysen and June Major Dolley, the legal counsel for Melvin Booysen was the applicant in this matter, actually stated that there is the statistic of, I think she had said 2% of false claims that are being made. And so even though, yes, we're seeking to protect the interests of all women who suffer at the hands of suffer sexual violence, that still those 2% of innocent men, they have rights that need to be protected. And it was a little unclear to us at the stage why the applicant's legal counsel made that statement and raised that statistic in relation to false claims for the following reasons. We know we have statistics in South Africa which show that there is a clear and shockingly low conviction rate of rape in South Africa. In fact, it is less than 10% at 8.6%. In our response in the court case, we also emphasize that the conviction of a perpetrator is not indicative of whether someone is telling the truth. So the problem with saying false claims is that there's also a lack in understanding of what that false claim actually is. Because to some, false claims are understood differently and could be, for example, when a woman reports the rape, but later withdraws that complaint at the police station, is that a false claim? Or is it when, for example, the woman reports the rape, it gets through to the investigation and the prosecutor, but the prosecutor decides not to prosecute the case because there's a lack of evidence? Is that a false claim? Or is it when the matter goes all the way, but that perpetrator is found not guilty? Do people then assume that the woman is lying? So do you understand the problematic context in the statement of the false claim? Because realistically, in the context of where women are situated in South Africa and where we are in relation to the power imbalance that lies within violence against women's bodies, we understand that women often do lay reports against their perpetrators. But when your perpetrator is someone that is intimate to you, it's your domestic partner, it is a family member, there are all of the social and contextual issues that go around and compound the vulnerabilities of survivors of rape. We have court cases, for example, that have long illustrated that if a woman decides to report her rape 10 years later, that is not indicative of whether she's telling the truth or not, or whether that's a false claim or not, right? Women should have the bodily autonomy and the choice to decide when to report that claim of rape, how to report it, and which resources to seek to assist her. Because we understand that there are women within our context, for example, there are women who are raped at work and do not want their spouses or their husbands to know about that because of the stigma and the rape culture, right, that presumes the woman is lying, the rape culture that treats perpetrators with impunity. And so that is the context in which we sought to brought before the court, especially in relation to this issue and statement of false claims.
Exactly. And we know, we also see, especially with the work context, is that they don't want to get fired. And by also being fired, even being stigmatized, and then just, you know, your job options sort of go out the window, which incidentally is also the case with Reverend June Dolley, because then she was prevented from working in the church, you know, and she's spoken about also being unemployed for a long time and what that meant then. So those are really important issues also for us to look at in terms of what keeps women from speaking out. Chrissy, so I want to ask, so my answer often to people when they bring up, because they have brought up on various platforms with me about the what about false accusations, you know? I'm also, well, the legal process is supposed to work in favor of an innocent man or person as well. If someone is accused falsely, the justice system should work to the extent that they can figure that out and find out about that. And have there been cases like that? I mean, this is just a sort of a random question, but here in our, the question does, I have two brothers. Sorry, I'm flitting here a little bit. But I do have to bring up, I have two brothers and I have three nephews is what I always tell everyone. And I often think about, you know, when we bring it down to in the community level, if we bring it down to in a family level where we know perpetrators are often known to victims, that they are ostracized on sort of many, many levels. And we've had survivors come onto the show and speak out about that. But when we speak about that context there, I guess I am asking, what are your thoughts as a legal person on the context for someone that may be falsely accused? And should they be worried about it? It's a very random question, and it's just speaking generally to the people who actually throw that out all the time.
So I think the starting point, like you had mentioned, is that there are various legal processes which are available to someone who feels that they are being defamed or accused incorrectly. And if those legal processes are followed correctly, it should provide a just outcome. However, and this is the context that we bring in these types of cases, is that we know that it is not that simple. The law is normative. The law is normative. It provides for formal equality, but it does not provide for substantive equality because the law is not colored with the context of gender-based violence in South Africa. Our counsel within this case made a very good example of, for example, a 16-year-old girl who is So these are the various types of contexts within which rape plays out. If you have a 16-year-old girl and she's at a party with a boyfriend or a boy that she likes, and they're consuming alcohol or not, and he follows her to the bathroom and asserts himself on her because they were at the party together. When she leaves that bathroom, what are her options? She is at a party by herself. Can she tell her parents because she had been consuming alcohol? Can she tell her friends because they would have seen her with a boy and therefore assumed that she consented? What did consent look like within that instance? Those are all of the contexts that play out in relation to reporting rape, innocence, and how when I started off saying that rape does not always look the way that people think that rape should look, which is the context of what these matters should be looked at.
Yes, I know you sort of, I'm relating it to a comment by one survivor before, where she was speaking about as she walked in and she was badly beaten up, the policeman actually said, now that is a real rape. And it stuck with me for a long time, because that is how we sort of contextualize these things. So we are sitting in South Africa, as June Dolley mentioned, the rape capital of the world. But I like to add that, actually on the World Population Index, South Africa is listed as the country with the most reported rapes in the whole world. We are sitting with a conviction rate, as you said, of less than 10%, which means that the majority of perpetrators do walk free. And there are various reasons for why the conviction rate is so low. But, we have to go soon. We're almost at the end of the interview. I wanted to ask, Chrissy, what is your advice, or what are your parting words to survivors of gender-based violence who have been raped? They are, I often still encourage them to report, because for various reasons, I think we need to build up data. I think we need more cases like this to be able to move forward. But obviously that is, their own decision and choice depending on what their support and circumstances are. What's your message as a woman, as an advocate, as a lawyer, and as the Women's Legal Center to women?
I think that as a starting point, the Women's Legal Center welcomes the judge as handed down on 30 August by Judge Bartman in the case of Melvin Booysen versus June Major Dolley. We welcome the judgment because it sends a clear message of hope to survivors of rape that says the courts will no longer allow the courtroom to be used as a further measure and tool to victimize, silence, gag women from speaking out. As a feminist, I want to reiterate that a woman's truth cannot be presumed based on a guilty finding or a conviction of an alleged perpetrator, because we know that the criminal justice system is flawed. We know that structurally, organizations and companies lead to impunity for men who are often found guilty of sexual violence, but are merely transferred to a different department, different unit. In this case specifically, the legal counsel for Melvin Booysen hampered on how his reputation suffered and the harm that he suffered. But oftentimes, rape culture silences women. It has a tendency of not believing women, and no one sees the harm and the reputational that the speaker of the sexual offense suffers. Women who report and oust rapists suffer the most. They suffer stigma from their community and from their families, from their employers, from their colleagues. They face harsh backlash, whether it's from the police, whether it's from loved ones. And so it is very brave for women to speak out and to do so publicly. One of the legal experts in one of the articles had said that he doesn't believe that social media is the platform in which to contribute to ending this gender-based violence within South Africa. And I would disagree with that. The president of South Africa has recognized that gender-based violence is a pandemic within South Africa. Women's bodies are violated on a daily basis, and the courts have realized what a vast violation this is on their constitutional rights to dignity and equality and the right to be free from violence. Social media, in the absence and in contribution to other processes, have proved to be quite useful, because where several women who have approached us have posted on social media, they are able to bring evidence of other women having the courage to speak out and saying to them, I suffered at the hands of this very man. And so women are building networks, communities of safety. And one of the issues that we had raised in this case specifically as well, men are going to court to silence women, but it could be very effective for them just to post on social media. Why are the men not nearly responding on social media. I know that that is not the way that the law would see it. And we know that that is not the way that men would feel is appropriate. But that is an option that no man is choosing to use, because if you lay a claim against me publicly, you are exercising your right to freedom of expression. I have that same right to freedom of expression, and I can say that this is untrue. Why are the men not saying this is untrue? I did not do this. Instead, they are coming to court to say, please silence this person because it is affecting me in this way. It is affecting my job and it is affecting my family. They're not coming to court to say, this is not true. I have said that this is not true, and these are the manners in which I've done that. So these are all of the context and the colors that these cases should be viewed in when making the determination. And we're very excited by the judgment as handed down on 30 August, but we welcome that judgment because that judgment, the judge specifically said that this case should be looked within that context, and that it is no longer just about the 2 people involved. It is now about the 8,000 women who are supporting Reverend June Major Dolley, have posted about this. And so the court was not only speaking for her, but for all of the women who have found the courage to speak out against perpetrators. And that is a beacon of hope that sends a message to survivors and that supports women to speak out, because as we wait for the criminal justice system to hold perpetrators to account, we know that there are flaws within the system. We know that there are flaws within other internal processes that are developed in the way that it lacks a victim-centered approach. Women who are violated, their bodies are violated, but within the criminal process and within organizations and misconduct processes, women are treated as witnesses to these processes. And so while we recognize that women must report sexual violence to the police, they must pursue criminal charges, they must pursue, for example, protection orders in terms of the Domestic Violence Act or the Protection from Harassment Act, where it is appropriate to do so. We also acknowledge the tool that social media has become for women in empowering them to create communities, to find a sense of healing, and to speak their truth publicly.
Thank you so much, Chrissy. And that brings us to the end of the interview. I want to thank you very, very, very much for joining us and giving us context. We are going to take a short break, but we'll be back with more after this. Welcome back. You're still watching The Womxn Show, and we are almost at the end of our hour together. But before we go, we're going to have a look at a short video by a new campaign called Just Us Here, where victims, survivors, and stakeholders in the GBV sector speak out about different issues. Let's have a look at the introduction and what this campaign is all about.
Sorry, that was terrible.
That's fine. That's fine. That's fine.
Women's Day in South Africa marks the anniversary of the historical Women's March in 1956. 20,000 women of color marched to the union buildings to protest against the apartheid laws that upheld the degradation and dehumanization of people of color. The apartheid pass law required people of color to walk around with an identity document. This was done to restrict our movement and reserve spaces for white South Africans. While we observe this day as a celebration of the iconic women of this time, we also need to recognize that we are not yet free. We are tired, we have lost heart, we are hurt, we are hiding in our fears, we're trying to protect our children, we're trying to uphold what society expects of us. We really are trying our best. The reason that we live in a country where there are so many experiences of rape and violence against women and children is a lot to do with the fact that men just can. There are many reasons that contribute to how this happens, and a big one is the failure of our justice systems not being able to adequately hold men accountable. Our community needs to better understand how to support women and children, and we need to stop shaming and silencing the topic. We need the system to work for us. We need our communities to believe us when we say that this is a pandemic. This Women's Month and Day, myself and some women engaged with this topic to provide a short video campaign to give a window of insight into some useful information when dealing with protection orders, approaching the courts with matters, and the voices of victims and activists. One of the greatest weapons we possess in the war against gender-based violence in South Africa are our voices and our shared experiences. We cannot stop standing up. We cannot stop sharing our stories. We cannot stop the fight that demands us to show up, soldiered and tall even though we are hurting and bruised. We hope this information empowers you to find the courage and resources to hold your perpetrators and communities accountable. This is a small part of the journey, but it's not impossible.
That was a video from the campaign Just Us Here, seeking to raise awareness about gender-based violence in South Africa. And that brings us to the end of our show. Thank you for joining us. I'm Lenina Rasool. Good night.